Abby C. in Lakewood, Ohio. So we've got an Ohio question popping up tonight.
Yeah, we do work in Ohio, as you know. We are
Mhm.
getting, uh, believe it or not, this video or this program that we're doing is getting a little traction in Northeast Ohio because there's a real estate group out of there that not as significant as the one that, well, they are significant, but not as large as the one that we're dealing with.
Sure.
But quite a few people I've been working with, and they've been circulating the videos. So we're starting to get,
Fantastic.
yeah, it's kind of cool.
Fantastic.
It's pretty neat.
All right.
All right, so Lakewood, Ohio, nice
Lakewood,
area.
Ohio by Abby C. says, I lent over $75,000 to a good friend to purchase a home. We were supposed to be partners in the deal. Oh, I could tell where this is going. Before I left out of town due to the pandemic, she closed on the investment home, telling me that we were both in the deal together. About 5 months ago, I learned that my name was not on the deed, and now she refuses to answer my calls or acknowledge that I gave her the money as we had initially agreed. How can I protect myself here? From Abby C. in Lakewood, Ohio.
Yeah, it's really unfortunate. This happens more often than not. Um, I actually, shameless plug, but I have a book that I wrote around, I think 3 years ago, called 2 or 3 years ago now, called Shady. And it's really about doing business with, um, having to do business with friends or relatives and how you protect yourself and the way you protect yourself always. I mean, spoiler alert is always to just have a written contract. Okay.
Yeah.
So they didn't have anything in writing, it doesn't sound like, and they trusted each other, or she trusted her friend, and something changed. So how do you enforce that agreement? Well, there's all these different outside, uh, supporting evidence. It may not be direct evidence like the actual contract between two people, and if there's none, uh, you can look to, you know, a check that $75,000 investment that was made. I'm sure it was made hopefully with a wire or a check, and so we can see that there's money being transferred. And if it let's say it went to a title company, um, at the very least, it may not have been intended that the parties own the property, but maybe she was a lien holder, right? There's something there that attorneys like myself can hold on to and point to a underlying contractual agreement, that we can, put, for lack of a better word, put somebody's feet to the fire. So what was that $75,000 for? Well, it had to be either she was meant to be a co-owner or she was meant to be a lien holder. Which one? Okay. And then you start digging, you can see a little bit more about how the evidence unfolds. But, my experience is that when we reach out, and this happens, honest to Blair, at least a handful of times every month, it's incredible. But when we do reach out to, these individuals who don't want to, they just don't want to follow through on whatever the bargain was, we send out our letters. 9 times out of 10, those people pick up the phone and go, you know what, we don't want any problems.
Yeah.
Let's straighten it out. So what we end up doing is it's really, kind of like triage. We get back in, okay, what did the parties agree to? And then we create the agreement, and then there are times, it's unfortunate that we do have to sue people over an agreement that was made verbally, and now we have to enforce it. And you can enforce these agreements in court, even if they're not in writing. There's all these exemptions to what we call the statute of frauds, which usually says everything related to real estate has to be in writing. And then there's certain exceptions. And we show the judge or the court those exceptions. So I feel badly for them or this lady, because that's a breach of trust.
Yeah.
But I feel very comfortable knowing that just from what we do, she most likely will be able to at least get her $75,000 back.